questions that housing provider may ask and may not ask. What are permissible and impermissible inquiries of prospective and current tenants? And going to answer quite a few questions here. What constitutes a blanket inquiry of an applicant's disability? Is it permissible to require an applicant to provide verification of their disability? Is it permissible to ask for a diagnosis? And specifically, what questions can be asked of applicants? Is there a list of permissible inquiries? And what if the applicant or a tenant brings up their own disability? Does that make it okay to talk about? Other questions are, can you prefer persons with a disability or a certain type of disability, like a wheelchair user in a barrier-free unit? Can you jump the line for someone who has a particular disability, put them ahead of people that do not have a disability? And what about persons with infectious contagious diseases? Are they covered under the Fair Housing Act? And what about people that have COVID afflictions? These are all questions that come up quite a bit, right? Can housing providers require that applicants or tenants be capable of independent living? Can they do in-home evaluations of an applicant before they move into the unit to see if they would qualify being able to live independently? And sometimes people are excluded because it's a direct threat. What kind of information is needed to make a direct threat determination? And there's a HUD regulation that applies to applicant inquiries. Does that apply to current tenants? Are there limitations on the kind of inquiries that can be asked of current tenants? And can current tenants be asked about their vaccination status or COVID test results? And the last part is, can landlords ask about someone's protected class status or category, like race, color, religion, so forth? Is that protected? What if the landlord doesn't even act on that information? These are all questions we're going to be asking. Quick, our ground rules. See the ground here. Ground rules. Webinar is being recorded. Questions go into the Q&A, not the chat. In fact, I don't even think I see my chat in front of me. I'll have to pull that up. And this webinar provides general information, is not intended to give legal advice. If you have more specific questions regarding a particular case or situation, please contact us. We're also going to do, a Q&A encore after this webinar is done for any questions that you may have that you don't want to make part of the training itself. And I'll turn the recording off, obviously, for that. This webinar will be posted on our website under Services and Resources. And the video we put on YouTube along with the PowerPoint, I'll put it there as well. You don't need to take detailed notes. You'll get the PowerPoint. I'm open source when it comes to PowerPoints and that. Videos, other webinars and conferences are also available on our website, on our YouTube page. And a big shout out to Mishta for the grant funding this webinar. We thank you and appreciate Mishta as well. So can't say enough about their support of fair housing. So here's our agenda. Here's what we're going to cover. 7 categories. First, Congress prohibit blanket inquiries by a landlord as to an applicant's disability. Then there's HUD kind of implementing what Congress said in the House report. We'll see that in a second. HUD came up with a regulation to implement what is permissible and impermissible applicant inquiries. And there's also issue of reasonable accommodation modifications. In other words, where the applicant or tenant initiates the discussion about a disability. And we're going to get into questions and cases that have addressed, there's an inquiries regarding the applicant's ability to live independently. And there's inquiries as to whether an applicant would present a direct threat. Now, 1 through 5 actually is dealing a lot with disability. And same with part 6, HUD's application, the HUD's regulation has applied to current tenants. Part 7, though, deals with other categories. It certainly can include disability, but it covers other categories as well. And we'll see what's permitted, not permitted, or more realistically, what's not permitted when it comes about asking about other protected class categories. And before I start here with Congress, prohibition of blanket inquiries by landlord as to disability, I want to make sure, not seeing your chat, just in case someone is putting something in the chat. I want to make sure, okay, I got it open here. I got 3 nice big screens anyways. So here's the first part to address. Congress prohibit blanket inquiries by a landlord as to a tenant's disability. What's important about this is you actually don't see this in the Fair Housing Act itself. It doesn't talk about blanket inquiries, but actually it's right, it's not there. But before we even talk about it, it's important to nail down what is a disability for purposes of the Fair Housing Act. And we could turn to the Fair Housing Act, but really the more detailed definition is found in HUD's regulation at 24 CFR section 100.201. Handicap refers to a physical and mental impairment that substantially limits one or more major life activities, a record of such an impairment, or being regarded as having such impairment. It's a three-part definition. Doesn't include current illegal use or abuse of a controlled substance. And you can look at physical and mental impairment includes, first one is any physiological disorder or condition. Subsection A2 is any mental or psychological disorder. You see how detailed these are. I'm not going to read it here, but for example, genital urinary, we worked on a case where someone, because of her medical condition, had incontinence, and there were complaints by the other tenants concerning the smell and so forth. And we were able, as a reasonable accommodation, they're really moving to evict her, to have her remove the carpet, put hardwood floors, have the chairs and that covered with plastic, have social work services coming in once a week, and it was able to address the condition and she would be able to remain in the unit. But genital urinary is a covered disability. When it comes to mental or physiological disorders, some of these are really, speech and hearing impairment. Someone's ADHD can be covered. HIV, you see listed here, HUD listed here in the regulation. HUD promulgated this regulation in it came out in, I think, March 1991. Emotional illness, drug addiction. See how detailed it is: emotional illness, mental retardation. But it doesn't cover drug addiction caused by current illegal use of a controlled substance or alcoholism. One last part, carrying out in the definition, has a record of such an impairment. Someone has a history or misclassified as having a mental or physical impairment, substantially limiting a major life activity, or is regarded as having an impairment. Their physical or mental impairment may not substantially limit one or more major life activities, but they're regarded as a person as constituting such a limitation. So those are the definitions. You can see Part 2, D2, a result regarded as limiting because of the attitudes of other person toward impairment, right? Or just treated as having it. So again, some can have a physical, I'll turn back here, get specific, a physiological disorder condition or mental or psychological disorder. They can have that. They can have a record of it, or they could be regarding as having such an impairment. That all qualifies within the definition of handicap for purposes of the Fair Housing Act. Just people that want to keep score, the ADA has a similar broad understanding of handicap. Now, when I say handicap, remember, that's because that's how it was adopted by the Fair Housing Act when it was amended in 1988 by Congress. The more common term, of course, is disability. If I'm quoting something, I will use the term handicap in the original quote, but otherwise I will use the more accepted and modern term disability. So when it comes to the legislative history for the 1988 amendments, the main legislative history is the House Report 100-711 in June 1988. It's the really main legislative history on the 1988 amendments to the Fair Housing Act. In the 1988 amendments, Congress added disability and familial status. And so House Report, you can see I'm quoting it from pages 29 and 30. I'll just read the italicized part. Well, I'll read up a little here. It says, in practical terms, a landlord may not, for example, refuse to rent it to an individual solely because the applicant used a wheelchair, is mentally retarded, or has a vision or hearing impairment, right? Similarly, if they have a history of it, it's insufficient for a landlord to determine whether or not to rent to that individual. You can't turn somebody down just because of that, right? However, right, the Congress made clear, right, they did not want landlords and owners to ask prospective tenants and buyers blanket questions about their disabilities. And Congress, when they added disability to the Fair Housing Act, they acted based on the understanding under Section 504 of the Rehabilitation Act, which was passed in the early 1970s. And then people that look at the ADA was passed 2 years after the Fair Housing Act, but really the Fair Housing Act is modeled or is heavily influenced by Section 504 and court decisions under Section 504 of the Rehabilitation Act. So here's what Congress wrote in the House report: in assessing an application for tenancy, a landlord or owner may ask an individual the questions that he or she asks of all other applicants that relate to the tenancy, meaning questions about rental history or whether the individual would engage in acts that would pose a direct threat to the health or safety of other individuals, right? That's getting into what? Someone's credit score, rental history, those kinds of things, provided it's asked of all residents. But they may not ask blanket questions with regard to whether the individual has a disability, nor may the landlord ask the applicant or tenant questions which require the applicant or tenant to waive his or her right to confidentiality concerning his medical condition or history. So you can see that's in the House report, even though that language did not find its way into the Fair Housing Act itself. And HUD, when HUD promulgated or enacted, I could now say enacted, published their final rules on the Fair Housing Act, it made clear, right, that they relied on the legislative history, that there was no, Congress did not want landlords and owners to ask blanket questions about persons' disability. And you can see, right, again, they're citing, HUD cited the House report. And they don't go into detail with it, but the reason is this: if someone is asked detailed questions about their disability, that's an act of discouragement. If someone is asked to waive all their confidentiality about their whole medical history, that's an act of discouragement. People with a disability would say, hey, let me walk away. I don't want to be here. I'm not comfortable, right? So it is an act of discouragement for people with a disability if they're going to be quizzed about their medical history and condition. So a couple of cases that have articulated this. You got to notice too, when I come here, I'm showing you, right, the House report, kind of the preamble, right, HUD explaining about their proposed rule that they would later enact or later promulgate it, effective 1991. But there's no regulation that talks about blanket inquiry. It's simply courts relying on the underlying congressional intent in the 1988 amendments. And this Laflame case is a leading case, right? Defendant New Horizons served adults who have limited mobility due to physical disabilities. And this is the criteria for residency. You can see the requirements that New Horizons was requiring. I think that was based on New York law. But the tenants receive responsibility for their own finance, emotional stability, control of bodily functions through natural adaptive means, and so forth. And they had a standard release requiring independent living. New Horizons not licensed or operated to provide medical care or supervision. As a tenant New Horizons, you must be able to live independently, right? The tenant selection process therefore includes an assessment of the medical and healthcare needs of each applicant. And you have been required to provide New Horizons Medical Villages all medical records and information which are deemed by New Horizons necessary for such an assessment. So what happened here? The court looked at it, and it's noted that their tenant must submit a prospective tenant must submit a form, seeks general information as well as details about the applicant's disability. And then they had a tenant selection committee required the applicant to authorize disclosure of comprehensive medical records and background information, right? And then the candidates, even further than that, had to appear before a committee for an interview and then have members of the committee come over for a home visit. During the home visit, they could be asked about his care needs and demonstrate transferring to and from a wheelchair. And then after that, they would then reconvene and make a decision as to whether someone would be suitable for the environment at NHV New Horizons. So the medical records requirement, right? It said it required them to disclose the records to enable New Horizons to verify the nature of the applicant's severe disability and therefore their eligibility, and substantiate whether the applicant would constitute a direct threat to the health or safety of others. But the forms, right, the court found went too far, requiring full disclosure of any all background information, records, and authorized release of medical information concerning present or past diagnosis, surgical operation report, and so forth, that's just overbroad. So that was an unlawful provision, right? So you can't ask for that. You can't ask for someone's diagnosis. All they can ask is information to determine whether the person has a covered disability. Another case, there aren't a lot of cases with overbroad, but here's another one in the Robarb's case out of Maine. There, the defendant, Cottonwood Associates, used the following health form. You can see the health form there. They wanted the physician to give a certification and give a brief description of the medical condition, including any past or present diagnosis, any surgical operation reports, psychological and psychiatric reports, current health status summaries, medical charts, and a current history and physical examination. That is broad. That is very broad. So the court noted there were basically two inquiries. The first required the physician to describe the applicant's medical condition, right? The second one inquires into the applicant's ability to care for himself and care for an apartment. The court accepted the second one. The parties didn't argue about that one. The applicant's ability to care for himself and to care for an apartment is fine. Certainly they can inquire as to that. But the first one, describe the applicant's medical condition, ends up being what? They can ask, a landlord is allowed to request that a physician verify an applicant's handicap. However, they're not permitted to require the applicant to provide the landlord with a description of the handicap. By requiring a description of the disability, the defendant exceeded the scope of permissible inquiry under HUD's regulation. When it comes to HUD regulation in a little bit. So that's an overbroad one, right? So question is this, right? We'll get into it in a second, but if it's an overbroad request beyond the scope of needing the information to assess whether the person has a covered disability, and the second part, whether their disability relates to, example, for a reasonable accommodation request, then it's overbroad. So the next part is this, and it really gets to the core of today's webinar. HUD regulations governing lawful and unlawful inquiries of applicants for housing. This is 24 C.F.R. 100.20 subsection C. So this is what you'd consider HUD's application inquiry regulations. Now, generally, the regulation prohibits inquiry as to whether an applicant has a disability or the nature or severity of the disability. It says here, it shall be unlawful to make an inquiry to determine whether an applicant for a dwelling, a person intending to reside in that dwelling after it is so sold, right, or anybody associated with that person, has a handicap, or to make inquiry as to the nature or severity of the handicap of such person. So first off, the general rule is you can't ask if someone has a disability or the nature or severity of their disability, or whether it's someone who's going to occupy the unit with that person or will be on the lease has a disability. Now, there are 5 exceptions where things that can be asked. It can be asked, and here, I'm going to give a summary on the next slide, but here, right, you can ask whether they have an ability to meet the requirements of ownership or tenancy, whether they're qualified for a dwelling or a unit made available only with persons with disabilities or a particular type of disability, whether they qualify to receive priority for a particular dwelling made available for persons with a disability or a particular type of disability. You can ask whether they're a current illegal abuser or addict of a controlled substance, and whether they've been convicted of illegal manufacturing or distribution of a controlled substance. Here's a good summary of it, right? Red light, green light. Red light, can ask whether they have a disability or the nature or severity of the disability. That's the default one. Now, Johnny's asking, can landlords and property organizations dictate the particulars, or if they will deny for criminal convictions, not only including CSC? Yes. And how, Johnny, good question. How that would fit would be under the permitted inquiries, part 1. And you can ask their applicant's ability to meet the requirements of ownership or tenancy. For example, their income, credit, rental history, criminal record would fit in there as well, provided that's asked of all applicants. We're going to have a later webinar dealing with the nuts and bolts of criminal inquiring as to a criminal record, but certainly you can ask that. Absolutely. because provided you're asking of that from all applicants, that is not prohibited. Okay, if someone has a disability, you can ask the same kinds of questions. You can also ask whether the applicant is qualified for a dwelling that's made available only to persons with disabilities or available only to persons with particular types of disabilities. Why this is important is this. Normally, you can't, like a gay-friendly building or, Black Lives Matter, so you want to give preference to Black applicants, right? Well, what happens is the opposite side, right, would be able to bring a claim because they've been discriminated against, right? On sexual orientation, right, opposite group of people would be discriminated against, so that would be unlawful. The only exception comes with disability. Non-disabled persons, if preference is given to people with a disability or persons with a disability, the other group, non-disabled persons, are not a protected group. So that's kind of the underlying theory as to why there can be a preference given to people with disabilities or a particular type of disability. And I've often suggested to people, did a webinar or a training with Detroit Land Bank, and sometimes they require a home that's fully barrier-free, has a ramp, the doorways have been widened, the kitchen and bathroom is barrier-free. Well, they can actually set aside that home for people, for example, that are wheelchair users or people generally that have disabilities. That's permitted. In fact, it's probably a good idea, right? Then letting the home go to someone or a family that does not have disability where they would need that kind of a home. But you don't have to. It's just an option. And another common one would be if there's a bottom floor unit that's barrier-free, right? So there's no steps, since someone, could easily go in and out if they have a mobility impairment or they're a wheelchair user. So the third permitted inquiry is whether the applicant is a current illegal abuser or addict of a controlled substance, or they've been convicted of illegal manufacture or distribution of a controlled substance. What would that consist of? Well, Congress thinking this way: legal manufacture, distribution of a controlled substance, that's a drug dealer. They have no fair housing protection once you have that conviction on your record. Okay, let me come back to Johnny's question because it's a good one. Say somebody has a CSC conviction, right? Criminal sexual conduct, or they're registered as a sex offender. Well, that would fit under the first category: income, credit, rental history, right? And some of this is required. For example, public housing, right? HUD occupancy handbook has prohibitions on renting to people who are listed on sex offender registry, so they can't be rented to. Okay, so that's a permitted inquiry because you're determining whether they meet the HUD standards for occupancy. Okay, so I think, to me, this gives some pretty clear guidelines as to what you can ask and not ask. All right, let's look at a couple case studies on this. Fair Housing Justice Center versus Cuomo. Housing provider terminated the tenant's lease because she needed supervision and or assistance with ambulation, transferring, dressing, grooming, toileting, and bathing. She filed a complaint with the Fair Housing Justice Center. They sent testers out posing as family members of older adults seeking assisted living and services. The testers were told, right, we don't have any, inquiring as to their family members who use wheelchairs. The testers were told, we don't have any wheelchairs here. Applicants have to walk for us. You cannot have any wheelchairs. And even though the applicant can get around and get off the chair and transfer that, we could not accept anyone in the wheelchair. Now, at the time of the test, state health regulations stated that assisted living programs shall not accept or retain any person who is chronically chair fast, unable to transfer, or chronically require the physical assistance of another person to transfer. But 1 month after the case was filed, the state health department, right, deleted those provisions that barred admission and retention of people who were chair fast. Right, the state never should have had that requirement at all. And the court found section 100.202 makes it unlawful to inquire whether the applicant for a dwelling has a handicap or make inquiry as to the nature or severity of a handicap of such person. So the New York statute on its face, right, well, the HUD regulation here in its face prohibited, right, the housing provider from making inquiries as to whether prospective applicants or testers asking about prospective applicants use wheelchairs, right? It does make a limited exception in HUD regulation if the dwelling is made available, giving priority to persons with disability or a particular type of disability, right? But that's a very limited exception. Permits the exclusion of applicants who are able-bodied in a manner which the target population is not. So, but here it was flipped around the other way. They said that they could exclude applicants who are disabled, right, from the majority population, right? They're not allowed to exclude someone because they're wheelchair bound, right? The only way they could ask about whether or not someone is a wheelchair user is if they're making specific units available for wheelchair users. So that violated the regulation. All right, so it comes up sometimes, often maybe, the applicant or resident makes the inquiry. In other words, it's not the housing provider or, you know, the management company, the condo association, the co-op board. Again, the management company is probably managing them, is bringing up the issue of the disability. Here is when the applicant or resident brings up the inquiry. Typically, that's done in reasonable accommodation or modification requests. In other words, right, the applicant or tenant is bringing it up. So what happens in a reasonable accommodation, a reasonable modification request? Then in that situation, the provider, once that process is initiated by the applicant or existing tenant, then the housing provider, meaning the management company, owner, so forth, is entitled to obtain information only sufficient as necessary to evaluate if requested reasonable accommodation may be necessary because of the disability. And I'm citing here both the joint statement of HUD and DOJ on reasonable accommodations and reasonable modifications. So the same rule applies, you know, it applies to reasonable modification requests as well. So how much information can a owner, management company, so forth, how much information can they ask concerning a person's disability? Well, it's a question. If the disability is obvious or clearly known to the housing provider, then they should not be asking. They don't need any additional information about the person's disability, right? For example, if they've seen the person using a wheelchair or a seeing eye dog, they don't need to ask for a certification, you know, medical certification concerning the disability, right? However, does that mean they can't ask any information? No, they can then, if it's necessary, ask for information about the disability related need, right, for the accommodation. Okay, we're accepting that the person is a wheelchair user. Okay, now, because you're a wheelchair user, what exactly is the necessity of the accommodation? For example, you know, need the mailboxes lowered or something like that as a reasonable modification. Okay, well then, you know, to what extent would you need them to be lowered and that kind of information? Well, that's permissible to ask about that. But you're not asking for someone to provide all the records of their diagnosis of having to use a wheelchair. And I've been in cases where I've had to provide that information. Really, you wouldn't think it would be necessary, right? Getting all the information of the diagnosis of the wheelchair, the cost of the wheelchair, when the wheelchair got, all the information on the wheelchair. Give me a break. The person's in a wheelchair. Not necessary. And how about on the flip side? Let's say the disability is not obvious or known to the housing provider. The classic one would be obviously with a, you know, emotional support animal, assistance animal, emotional support animal, and ESA, right? You can't typically you can't look at someone and say, oh, you know, they have a mental disability such that their condition is ameliorated or aided by the assistance of a support animal. You can't tell in that situation. It's not necessarily an obvious disability that's known to the housing provider. Then the provider may ask for information, however, limited only as necessary to evaluate the disability-related need for the accommodation. So what can be asked? Can ask for information necessary to verify the person meets the Fair Housing Act's definition of disability, That's usually provided by the medical or the healthcare provider. Again, not necessarily a physician or a psychiatrist. It could be a psychiatric social work, and other people that work in the mental health field could provide that certification. The certification should describe the needed accommodation, and showing the relationship between the requested accommodation and the person's disability. Now, this is the same kind of analysis that applies whether it's a reasonable accommodation request or reasonable modification request. And HUD has also assistance animal guidance, has that same standard as well. And then there's a little bit of guidance in terms of what qualifies and what meets the definition of the Fair Housing Act's definition of disability. And you can see this is on the joint statements: a doctor or other medical professional, peer support group, non-medical service agency, reliable third party who's in a position to know about the individual's disability, and may also provide verification of a disability. Believe it or not, I mean, there's federal circuit court decisions that also consider the applicant's or tenant's own verification as to their disability. That could be provided as well. Questionable whether that alone would be sufficient, right? Typically, you want some kind of independent verification as to a person's disability. So those are the main standards. The joint statements on reasonable accommodation and reasonable modification give some examples. Here's one. Applicant who regularly uses a walker to move around, right? Asks for an assigned parking spot near the entrance of the building, right? Closest to her unit where she would enter and exit the building, right? They can't ask that applicant to provide additional information about their disability or even the need for a requested accommodation, because that's obvious, right? A rental applicant uses a wheelchair, advises housing provider wishes to keep an assistance dog in his unit, even though they have a no pets policy, right? The disability is apparent. You've got a wheelchair user, but the need for an assistance animal is not readily obvious. So the housing provider may ask to provide information about the disability-related need for the assistance animal. Vision impairment, someone needs assistance filling out a rental application as a reasonable accommodation because of the disability. If the person can't see, right, has a vision impairment, right, difficulty seeing, right, you can't require someone then to document their vision impairment because that's going to be considered obvious. By the way, these are in the joint statement of HUD DOJ. In the absence of specific guidance under the Fair Housing Act and HUD regulations, courts will give deference to the policy statements of HUD and Department of Justice. So it's with risk that anybody would not use these examples as good guidance in evaluating a reasonable accommodation, reasonable modification request. And again, we're talking about applicant inquiries, and these are inquiries as to disability when the disability is raised by the tenant or applicant. Examples of reasonable accommodation in the joint statement, right? Someone asks for a motorized scooter to move around and ask permission to install a ramp. No need to ask someone to provide medical information or medical certification about the disability or the need. That should be obvious, right? A deaf tenant asks him to housing provider to install electrical lines and a cable so the tenant can use computer equipment that helps him communicate with others. The disability is known, right? The housing provider may not require the deaf tenant to document the disability. However, for most housing providers, they're probably not going to be aware of the need for electrical and cable lines, right? So they may request information to show the disability-related need for the requested modification. These are big deals. I had a case where the person had just dystonia, very severe medical condition, and instead of allowing her to have a ramp for her property, they said, well, you need to move to another unit where your ramp can be just straight and not having to turn. It's like a better unit to install a ramp. The problem was this: for her to move from one unit to the other could risk her life if there was any delay in having her electrical medical equipment hooked up. So it's a really, really serious concern, right? On deaf tenant here, people don't realize the potential liability in fair housing cases. For example, well, if they delay on the need for electrical and cable lines, okay, suppose, there's a fire or something and the deaf tenant, is not aware, doesn't get the notification, right? It can be very serious, right? So underlying these things are cases of really significant liability. Respond promptly to reasonable accommodation, reasonable modification requests. Another part that goes with this is confidentiality. When a tenant brings up the issue of their disability for purpose of reasonable modification or accommodation, or it's raised by the housing provider because they have units that are set aside for persons with disability or a particular type of disability, any medical information that comes in, it's kept confidential, only shared with other persons as necessary to make the decision whether to grant or deny reasonable accommodation or modification request, or disclosure is required by law. For example, some offices say, well, when we get a reasonable accommodation modification request, well, those things we treat very seriously. They're handled at the main office or corporate handles it. Well, we provide that information to corporate. That's fine because that corporate will make that decision. However, the office where the medical information comes in corporate is required to keep that confidential. People always ask, well, what about HIPAA? Does HIPAA apply? No, it does not apply to landlords and property managers. It only applies to medical providers, medical service providers. It's limited. So there is no HIPAA requirement, right? Landlords, owners, property managers, they're all subject to confidential requirements concerning medical records and medical information under the Fair Housing Act, not under HIPAA. Why I get concerned about it, because it came up, I was discussing with somebody last week. Someone was doing a fair housing training, and basically what they said is, well, when you get a fair housing complaint, you're investigating a fair housing complaint, have the complainant, right, submit a HIPAA release. Well, you don't want to submit a HIPAA release. HIPAA release will allow blanket disclosures of medical records and information that's beyond the scope of permissible disclosure under the Fair Housing Act. So no, don't do HIPAA. There may be times where you need a HIPAA release, for example, in a complaint, before a treating physician can share that information. There may be instances where you would want a HIPAA release in that, but don't just default and automatically have people sign HIPAA releases. All right. The HIPAA release may apply to the medical provider, but it doesn't apply to landlords and property managers. You don't need, and you don't want HIPAA releases. It's not going to do anything for you. It's a waste of time doing it. Any questions about that? I found some HUD complaints and a court complaint concerning people that were evicted. About 70 people were evicted from apartment complex, and basically they were in a drug treatment program. And the treating agency was the tenant, would have number of leases, 2 and 3 bedroom unit properties, and they, as a condition or as a benefit of people going through their program, they would then live in those units, in a 2 bedroom 4 people, in a 3 bedroom 6 people, and they live in those units. And the actual provider, right, the drug treatment program provider, was the tenant, would make all the rent payments and always on time for 15 years. But they decided they want to go with a different clientele and booted everybody back. And so they all had to leave, and they had to scramble to find other places for the people to live. Now, before we got information from basically the agency that provided the drug treatment program, in that situation, yes, they were not going to share anything with us till we obtained HIPAA releases for each of the people that were willing to go forward and present a claim. So we obtained HIPAA releases. But we needed that in order to proceed with the case. But that's because we were dealing with again, we weren't asking that from a landlord, property manager, owner. We were asking that from a medical care provider, mental health care provider, drug treatment program provider. So then we asked for HIPAA releases. But that's the only time. So here's question came up quite a bit. Overview of the Fair Housing Act when it applies to COVID-19. Now, to drop back, we got to take a quick look at the Rehabilitation Act. The Rehabilitation Act, Section 504 was passed, again, in the early 1970s. It defines a handicapped person in the regulation, and It does not list specific diseases or conditions that constitute physical or mental impairment. And here's what HUD said in reviewing Section 504 HUD in the 1988 amendments. They, in deciding, to put the mental status and disability as part of the Fair Housing Act, include them as protected class categories. They took a look at how infectious diseases in that were covered under the Rehabilitation Act. And they found that Congress, when they passed the Rehabilitation Act in the early 1970s, did not come up with a comprehensive list of contagious infectious diseases because of the difficulty of ensuring a comprehensive list, and because some conditions covered in the definition of handicap may not even be discovered or prevalent at the time of the passage of the legislation. Good approach, obviously. So in the Fair Housing Act, Congress was considering Fair Housing Act, they added disability, but Congress at that time was really concerned about the treatment of persons infected with AIDS. AIDS was a big concern in the 1980s. So there was an amendment that would have excluded from the definition of handicap any current impairment that constitutes an infectious, contagious, or communicable disease, whether or not such disease caused a physical or mental impairment during a period of contagion. So that it was defeated. The amendment to exclude AIDS or HIV was excluded. So Congress left a broad definition of disability in the 1988 amendments, adding disability as a protected class category. So, and it turned out to be wise, right? Because at the time they passed the 1988 amendment, like they did with Section 504, Congress said, hey, there could be new conditions, contagious diseases that could come up. We want to make sure, I think, that they're covered. So the 1988 amendments made clear, and even in the HUD regulation as well, that physical or mental impairments extends to persons suffering from communicable diseases, including AIDS and HIV virus. And also going beyond it, the Fair Housing Act extended coverage to those who have a record or being regarded as having a disability. So the point is this, say someone, if they have long COVID, they could still be covered as a disability, but for some people, it's a shorter, more temporary one, but they could still be covered because they have a record. People with COVID or had COVID have a record of a disability, or persons suspected of having COVID can be regarded as having a disability. Whether or not they do, similar to the way persons with communicable diseases can be regarded as having a mental or physical impairment. So the question here is, can applicants be asked if they have COVID? No, right? HUD's regulations prohibit housing providers from asking applicants health-related information, disability-related information, and that HUD regulation, which governs the application process, what can be asked or isn't asked, is typically applied even to current residents, right? Can you ask tenants for their COVID test results or vaccination status? No, probably not warranted to require it, right? And HUD National Housing Alliance has a little guidance on this, asking for information about the nature of a communicable disease or asking about evidence about exposure test results would generally violate the Fair Housing Act. Housing providers and housing service providers should not require homeowners, applicants, or tenants disclose whether they have a medical condition that make homeowners, applicants, or tenants particularly vulnerable to COVID-19. All right, how about dealing with an applicant's ability to live independently? Can you ask about that? We touched on a little bit in the earlier cases. On the Flame case, right? The exclusion of plaintiff and other people who have mobility disabilities who have been deemed by the housing provider to be incapable of independent living can be viewed as best a paternalistic attempt to direct these individuals to more suitable housing, and at worst, prejudicial discrimination. Either way, the exclusion of those who do in fact suffer from a mobility disability but who are not able to live independently is violative of the Fair Housing Act and is not condoned, right? And independent living is not a proper admissions criteria for 811 housing. Answer is no, you should not ask whether they can live independently. The Carson versus Rochester Housing Authority is another important case the standard for tenant selection criteria, allow consideration of applicant's ability to live independently or live independently with minimal aid, right? Ability to live independently means they're able to perform basic functions of adult living by him and herself, understand and sign contracts, legal documents, perform basic housekeeping and personal care, perform necessary daily activities, but understand and conform to applicable standards of safety. And they also undergo an in-home evaluation and have to complete a questionnaire, right? And they made a decision. Here's a real revealing one: to accept or reject the application. In many instances concerning applications from disabled individuals, the decision to deny housing is strictly based on the applicant's perceived inability to live independently. There was no reported rejections for non-handicapped persons for this reason. So disparate impact, right? Only disabled persons were turned down based on the ability to live independently. No non-disabled persons were denied housing based on that standard. And it's a regulatory violation, right? They permitting inquiry into an applicant's ability to meet the requirements of ownership or tenancy. The court did not see, right, under consistent with HUD's regulation, a requirement that a resident be able to live independently rather than with the aid of others. And then the defendants argued about a direct threat, no indication that someone with a disability or the inability to live independently creates a direct threat. So that would be unlawful. Janine case kind of goes back even further, 2001. Plaintiff had a spinal injury, paralyzed from the waist down. He has a close relative who resides with him and provided personal care. During the interview, they questioned him regarding the nature and severity of his disability, that's overbroad, as well as ability to use toilet facilities, cook, drive, and otherwise care for himself. They turned him down because of the belief he was not ready to live independently, right? And the court looked at the HUD handbook and states that Section 811 housing designed for those people who have a physical, mental, or emotional impairment which substantially impedes a person's ability to live independently, right? The requirement of an independent living requirement was contrary to Section 811. And so the court granted partial summary judgment for the plaintiff, meaning plaintiff wins on this part of the case without even a trial. The only trial will be as to the damage to be awarded to the plaintiff. The exclusion of plaintiff and other persons with mobility, the disabilities deemed, because they're deemed incapable of living independent, can be viewed as best paternalistic, right? As worse prejudicial discrimination. That's a violation. So the point is what? It's high risk to turn someone down because they're not capable or believed to be not capable of independent living. There's a couple additional sources of guidance. This is from the Fair Housing Center of Central Indiana. They do great work. And independent living, right, describes senior housing communities that do not provide medical or other support services, right? That's a general fair standard, right? But it can lead housing providers to require their residents live independently or without help or aid. In other words, before someone gets turned down because they're unable to live independently, the question is what? They may actually be able to live there if they have some support with their personal care, chores, maintaining their unit, etc. And other resources could be brought in to make those daily tasks. Absolutely, really, the safest request is to have who makes the decision. The applicant, or the applicant and their family makes a decision whether they are able to live independently with or without resources to be able to occupy a unit, right? And then in situations where the resident needs additional assistance in their daily living, a housing provider cannot limit the amount of outside assistance that a senior with a disability provides or obtains for himself or herself, right? So they can ask for reasonable accommodations for part-time, full-time, even live-in aids in order for them to remain in the home, or what they say, age in place, right? Now, and this is, from the guidance here, if the housing provider does not normally provide maintenance or other supportive services, it's the tenant's responsibility to make suitable arrangements with outside sources to obtain any necessary assistance. There is also that occupancy handbook Chapter 2 deals with civil rights and non-discrimination requirements. It has the direct statement here when it comes to HUD housing, HUD multifamily housing. It is unlawful for an owner to make inquiries designed to determine whether an applicant may live independently. Gordon has a guidance, American Seniors Housing Association, Seniors Guide to Fair Housing and ADA Compliance, has a about 4 or 5 page discussion as well on the requirement to maintain independent housing. So the bottom line is this: be very, very careful to impose an independent living requirement. It can be independent living, but the safest approach is to let the tenant and their family make that decision. If someone decides, oh, we're going to exclude someone as an applicant, we're not going to approve them, or we're not going to allow someone to continue here because they no longer meet the independent living requirement, well, that's a different question entirely, right? The decision should be made by the resident or the resident and the family. Well, they'll just stay there and they can't do whatever. Okay, then call Adult Protective Services or something like that in order to get the assistance that someone needs. Let them make the decision to relocate someone to a new housing location or facility that will meet their specific needs. But you don't want to be in that situation of making that decision for them. I hope this is clear. So the next question is this: what kind of inquiries can be made as to whether an applicant would present a direct threat? Again, it's a permitted inquiry under the HUD regulations. It's a permitted inquiry under the Fair Housing Act, right? There is a direct threat exception in the Fair Housing Act. It's buried 804F9. Nothing in Section 804 dealing with, persons with disability, reasonable accommodation, reasonable modifications, disability discrimination, design and construction, right? All of that is in 804F. And it says nothing in Section 804 requires that the dwelling made available to any person whose tenancy constitutes a direct threat to the health and safety of other individuals or whose tenancy would result in damage to the property of others, right? If they're a direct threat, they're not protected under fair housing. And HUD's implementing regulation kind of repeats the Section 804F9 of the Fair Housing Act. And in their kind of narrative regarding the rule, HUD wrote, this provision was not intended to create or permit a presumption that individuals with handicaps generally pose a greater threat to the health or safety of other individuals other than do individuals without handicaps. And so what they noted here, HUD then noted it's to be interpreted consistently with the School Board of Nassau County versus Arlene case, 1987 Supreme Court case, which addressed employment discrimination under Section 504. Supreme Court in that case held that a person who has a contagious disease of tuberculosis can be an individual with handicaps within the meaning of Section 504, right? And the court said that any employee who poses a significant risk of communicating contagious disease to others in the workplace will not be otherwise qualified for his or her job if reasonable accommodation will not eliminate that risk. And so Congress, in going through for the 1980 amendments, wanted the Fair Housing Act amendment, including, the amendment to include disability, to have the Fair Housing Act interpreted consistent with the Arlene decision. And the House report said that while Arlene dealt with employment discrimination under Section 504, Congress wanted the same standard to apply when it comes to housing, fair housing. Thus, the direct threat in the Arlene standards applies. But the key part here is at the bottom. If a reasonable accommodation could eliminate the risk, entities covered by the act are required to provide such accommodations under 100.203. That's a section of the HUD regulation dealing with reasonable accommodation, right? And going further on this, on the HUD report, any claim that individual's tenancy pose a direct threat and substantial risk of harm must be established on the basis of a history of overt acts or current conduct. Must be specific evidence of overt acts and current conduct. It can't be based on generalized assumptions, subjective fears, and speculation. That doesn't prove a direct threat, right? It has to be objective evidence, credible, not from unsubstantiated inferences that the person posed a direct threat, right? It has to be that. before someone can be rejected as an applicant or have their lease terminated as a tenant, or the co-op share, removed from a co-op or condo property, right? The landlord may not infer a recent history of physical mental illness or treatment for such condition that constitutes proof that the applicant will be unable to fulfill his or her tenancy obligations and constitute a direct threat. There's a couple cases on this. HUD v. Courier. What happened here? Respondent, it was amazing, right? Respondent required, as to the Mr. Walker, they treated Mr. Walker, required a $100,000 insurance, $1 million insurance policy to protect the landowner from any problems that might exist due to her brother's condition. The brother was Mr. Walker. The tenant had to sign a paper to be responsible for any damages caused by her brother, and they wanted a note from a doctor about the brother's condition. And respondent admitted that all these conditions were required because of Mr. Walker's disability. So what was the concern, right? His view, it was his subjective view, the persons diagnosed with autism and mental retardation pose a greater risk in terms of liability, right? So why was all this required? Well, the first person, was autistic and had mental retardation, right? And he also admitted he doesn't require that kind of a note or requirements, doesn't require liability insurance, doctor's notes, hold harmless statements from tenants or non-disabled tenants that he imposed on Mr. Walker and Mr. Walker's family. And there was no objective evidence produced in the case showing that Mr. Walker posed a direct threat to property or surrounding neighbors, right? There was no proof of that, right? That's based on purely what? Subjective beliefs about Mr. Walker, right? And he said, it's amazing. He testified that he relied on the fact that a red flag went off in his head when he heard that Mr. Walker had a disability. Respondent testified he had seen autistic children flailing their arms and hollering and screaming in outrage, and observed autistic children running into walls and running around the kitchen and making noise. What's that got to do with Mr. Walker? What's that got to do? That's subjective, prejudicial stereotypes as to people with what? Autism, mental retardation, but that's not specific to Mr. Walker. I don't even think that satisfies sufficient evidence as to autistic children, right? They subjected Mr. Walker to highly offensive statements, concluding he was worried about Mr. Walker burning down the house and attacking neighbors simply because Mr. Walker was autistic and mentally retarded. Record shows respondent discrimination based on unfounded generalization and stereotypes regarding individuals with autism, right? They're unfounded. That's the various kinds of unfounded speculation Congress sought to ban when amending the Fair Housing Act in 1988. I had a case where the tenant, or my client, had a mental health disability. She went in, this was in the Ann Arbor area, met with the housing provider, and everything was discussed, and she had SSDI income, which it was sufficient, and received the application, and while she's going through viewing the unit. Then the housing provider, the owner, says, well, what kind of a disability do you have? Is it physical or mental disability? She goes, oh, it's mental. And the owner then snatched the application back. Oh, no, I've had too many problems with people with a mental disability. Then that was one thing. So then it's so sad. This was the second time this particular woman had been turned down because of a mental disability. So she contacted her caseworker. Her caseworker contacted one of the housing providers, and the housing provider said, "We'll tell you what I will do. I will rent to her, provided that you have someone on call 24/7 to respond if there's kind of an emergency because of her mental health." So the question is, do you think the housing provider required that there be someone available 24/7 for other tenants that don't have a mental disability? Absolutely not. Was there any evidence that that kind of a service would be needed for this particular applicant? No, not at all. but that's based on subjective views and opinions because of someone having a disability, right? So the point is this: if it's a direct threat to the health or safety of other tenants, the management company, staff, maintenance staff, or a threat to the property of others, it cannot be based on stereotypical notions, unsubstantiated stereotypes concerning people with a disability, right? And if it is, that is a clear violation. It has to be objective, credible proof of specific instances in which someone is presenting a direct threat. Otherwise, it's a clear violation of the Fair Housing Act. So here, question here is, does HUD application apply to current tenants? Again, 24 CFR 100.20C, right? It addresses inquiries of applicants, doesn't really state whether it applies to inquiries that a housing provider can make of current tenants. So that's the question, does it apply, right? Right? The house, and here's why. It has been applied to current tenants. In other words, section 100.202C governs what a housing provider can ask of current tenants. And here's some of the proof for that. In House Report 100.70 states as to the direct threat exemption, nor may the landlord or owner ask the applicant or tenant questions which require the applicant or tenant to waive his or her right to confidentiality concerning his medical condition. So it's clear Congress wanted the direct threat exemption not only to apply to who? Applicants. It can also obviously be applied to current tenants or current occupants. And another portion of HUD statement, when they implement the final rule, housing provider may judge handicapped persons on the same basis it judges all other applicants and residents. However, housing provider may not treat handicapped applicants or tenants less favorably than other applicants or tenants. And HUD in policy statements consistently applies section 100.202C to questions asked of current applicants. In the HUD v. Williams case, there's not a lot of authority on it, but HUD v. Williams case is the one that I was able to find, that since the House report and preamble is the statement that HUD provided with the Fair Housing Regulations, support the interpretation that sitting tenants are included, and since there's no reason readily imaginable or to argue, support the concept that Congress would intend protection from intrusive questioning for prospective tenants, but not sitting tenants, I find that section 804F of the Act and section 100.202 provide that owners of housing do not have the right to ask sitting tenants as well as prospective tenants blanket questions about their disabilities, right? If that was allowed, right? If they could ask blanket questions about existing tenants, blanket questions about their disabilities that bear no relationship to the health or safety of others, create an open season on the privacy rights, sensibilities, and civil rights of persons with disabilities, and would thereby violate the Act and the regulations. Well said in HUD v. Williams. Right? How about inquiries as to current tenants, COVID-19? You know, this maybe COVID-19 will fade away as an infectious disease. I sure hope it will. But this will come up. There'll be other infectious diseases. Unfortunately, it just seems like the human condition, right? So we need to know what those answers would be. Again, may current tenants be asked about their COVID test results, their vaccination status? No, right? The current view is a regulation restricting the questions that can be asked of applicants applies fully to tenants. What should a housing provider do if there's a known case of COVID at a multifamily property? The same way they would respond to any other dangerous condition like known criminal activity on that property or hazardous situations. They can take steps consistent with CDC guidelines to reduce the risk. Once that becomes known, have the tenant voluntarily quarantine themselves. There can be safety precautions and so forth, right? Provided, right, that, I'll get to the confidentiality part. And the housing provider may consider warning residents of the risk without identifying who the tenant is, because you can't share that information, right? Can the housing provider provide tenants with health information concerning other tenants? No. Medical and health information concerning tenants and applicants must be kept strictly confidential. You can't give their names and unit numbers, the situation with one municipality, they managed property, and tenants wanted to know the names of other tenants that had COVID, so, and what floor they were on and their unit numbers so that they could take precautions, right? My advice is no. Well, they said no. The tenants didn't like that answer, so they quote unquote contacted Fair Housing. So I wrote a letter out to say, no, you can't give them that information because it has to be kept confidential. They wouldn't accept it from the municipality, but they did accept it coming from Fair Housing, obviously, because we're pro tenants for the most part, right? Hopefully all the time. And what is the information relating to an individual's disability and health conditions must be kept confidential, cannot be shared with other persons unless the information is needed for evaluating whether to grant or deny reasonable accommodation request, or unless disclosure is required by law. One last thing, right? What if someone with an infectious disease refuse to self-isolate or take precautions, right? The housing provider can take steps to protect residents and staff, right? Because at that point, the person is a direct threat. And again, the direct threat must be based on facts, objective evidence, credible, accounts. It cannot be based on speculations or fears or stereotypes concerning people with a particular type of disability. And here, 3 factors are real important to consider: nature, duration, and severity of the risk of injury, whether the probability that injury will actually occur, and whether it is reasonable accommodations that will eliminate the direct threat. Before doing anything along this line, legal advice should be sought. It's key too to get insurance coverage, right? Liability policies to obtain coverage for losses relating to viruses. So the last part is, again, moving a little bit from disability, although it still includes disability. How about inquiry as to race, religion, and other protected class categories? In other words, what can a housing provider, seller, property management company ask when it comes to protected class categories? And here, right, the standard is crystal clear. It is unlawful to inquire as to the race, religion, or other protected class category of an applicant or a buyer. Sewell versus HUD, it said racial inquiries may violate 3604C because there's simply no legitimate reason for considering an applicant's race. The rule is this: unless there's a specific law requiring someone to ask about the race or other protected class category, you can't ask. For example, the Home Mortgage Disclosure Act requires lenders to inquire as to the race, ethnicity, and sex of applicants and age, right? That's required under the Home Mortgage Disclosure Act, so that can be asked. If it's other kind of financing, you can't ask. There is no requirement permitting someone into a rental situation or co-op or condo situation for asking about the protected class category of an applicant. It's not permitted. Inland Mediation Fair Housing Council versus roommates.com, the Ninth Circuit said a real estate broker may not inquire as to the race of a prospective buyer under the Fair Housing Act. HUD v. Blackwell, homeowner violates 3604C by asking broker the race of potential buyers. There's a lot of violations of that going around. HUD v. Roberts, administrative law judge, found that inquiries about race are not reasonably related to qualification for housing and would lead a reasonable person to assume that race was being used as a factor to determine eligibility. And HUD v. Janik avoided the question because the context, they did not intend to discriminate on the basis of race, right? I don't know how strong that decision is. Snyder, right? They have in Snyder decision out of the Third Circuit, court upheld a jury verdict based in part on the Fair Housing Act against a landlord who sought information about plaintiff's religious affiliation and then refused to rent to them because they were Jewish, right? And Housing Rights Center versus Donald Sterling Corp., right? the court found a likelihood that the plaintiffs would win because there the housing provider was asking the tenant to state his or her national origin as part of an application for apartment-related services, and that violates the Fair Housing Act. A recent case, HUD Administrative Law case, HUD v. Dangtron. The respondent, a couple of respondents actually, placed a housing advertisement on Craigslist, and here's what it stated. I have one part of it. I have one room available for renting, 5-bedroom home for professional only. If you feel qualified, please respond with your brief description about yourself, race, and age, and a recent picture of you. That is a direct request for age, race information, right? Complainant viewed the advertisement, contacted respondent to express an interest. Then the respondent said, oh, you got to provide a picture of yourself. She declined to do so. Later on, I guess she's having trouble finding housing, or he was unable to find a tenant. So he called back and they agreed to meet at the property. When she went and met him at the property, he did not permit her to enter the home or view the room. She says that he said he could not rent the room to her because she's Black, right? And other people wouldn't feel comfortable with this. And respondents denied it. He said he refused to show her the room because she said she would cook a lot. Right? What do you think? Right? And the respondents argued, well, an ordinary reader would not perceive their advertisement as discriminatory because their use of the word race was general. It didn't refer to any particular race, right? The HUD Administrative Law judge found asking applicants to disclose their race indicates an intent to consider race as a preference or limitation when selecting a tenant, thus inquiring prospective tenant's race and housing advertisement is facially discriminatory. Meaning what? On its face, it's discrimination even to ask about someone's race. The point is this: you can't ask anybody about, their race, religion, national origin, color, none of those things. The sad part is, I think I'm seeing some of this in cases, for example, in home sales. Often, sellers won't know the race or protected class category of buyers, but now they're leaving like cameras in the home where a prospective buyer comes to the home and they'll know what the race is because they've left cameras up, and that is really sad, that we're in a situation where a person's race and color and those factors are still being used against people. It's very, very sad. But the bottom line rule is this: you can't ask about anyone's protected class status. The only exception, again, is going back to the HUD regulation, is if the property is a unit is set aside for persons with a disability or a particular type of disability, right? Or, you can see whether they're, well, that's only protected class category. The part about asking about whether they're a current user or abuser of a legal controlled substance, well, that's not, race or color related or any national origin related, right? That may arguably impact on disability, but that is a permitted question. So bottom line, let's go through these questions, these 10 or so questions. What constitutes a blanket inquiry of an applicant's disability? Do we have specific answers to these questions? I think we do. Examples include asking overbroad questions as to the description, nature, or severity of the disability, right? Or, for example, the diagnosis of the disability. You don't have to ask a diagnosis or not. No, just whether they have a disability is all that's required. Anything else is overbroad. Or asking the applicant or tenant to waive confidentiality concerning their medical condition, information, or history. That's a blanket inquiry. How about the second one? Is it permissible to require an applicant to provide a verification of disability? Is that permitted, right? Or can ask about the diagnosis of an applicant's disability? Yes. If the disability is one that is not obvious. If the disability is obvious, then no, you can't ask. And how about the diagnosis? No, it's impermissible to request the diagnosis of a disability. So what inquiries can be made of applicants? There's a list of permissible inquiries. What if the applicant or tenant mentions or initiates the discussion? Permissible inquiries, again, are listed in the HUD regulation. If the applicant what can you ask? You can ask information about the person's qualifications for rental or occupancy, provided it's asked of all applicants, meaning whether their income, credit, rental history, criminal record meets the qualifications, provided the same standards apply to all applicants. That's it. You can ask whether if they have a disability, a particular type of disability, if units are being set aside for people with a disability or a particular type of disability. You can ask whether they're, inquiry as to a direct threat, an inquiry as to whether they're convicted of the illegal manufacturing or distribution of a controlled substance. That's it, right? How about if the tenant or applicant brings it up, right? Then the housing provider can ask information only as necessary to determine the existence of a non-obvious disability and the disability-related need for the accommodation. The other ones, can you prefer persons with a disability or particular type of disability, such as wheelchair users, or jump the line for persons with disability, particular type of disabilities? Yes, you may. Are persons with infectious, contagious, or communicable diseases covered under the Fair Housing Act? Yes. As to the first question, are persons afflicted with COVID included within the definition of disability? Yes. Perhaps, maybe if the short-term condition, person is no longer disabled, short-term COVID, things of that nature, they still may be covered if they're being treated adversely because they have a record of an impairment or regarded as having an impairment, even though it's not a current existing disability. Can housing providers require that tenants be capable of independent living? Can they conduct an in-home evaluation of the home where the applicant or applicants currently reside to determine their ability to live independently, their housekeeping skills and abilities and so forth? Generally, no. Housing provider may not question whether an applicant with disabilities can live independently. In-home evaluations create a risk of fair housing liability. For example, you do and there was a housing provider actually did this. Required a form to be filled out. These are not just abstract. And well, you find out their race, you find out their color, you find out, all kinds of things about the person in those in-home visits. I recommend that those not be done. Any concern, what should you do to determine whether the person is qualified or meets the requirements for tenancy or occupancy? Get a standard rental verification from the existing landlord. Do it the way you would with any other type of applicant, right? The way you would do for any other applicant, rather than doing these home visits. What kind of evidence is needed to exclude a person as a direct threat? Must be based on objective, credible evidence, can't be based on inferences, subjective beliefs about whether a person with a particular type of disability would be a direct threat to themselves, others, the property, and so forth. Can't just rely on the medical condition, psychiatric condition, or information, or treatment for it. Has to be based on objective facts, objective evidence that the person legitimately constitutes a threat. Does HUD regulation pertaining to applicant inquiries apply to current residents? Yes, same standard that applies to inquiries of applicants applies to inquiries of current tenants. Can tenants be asked about their vaccination status or COVID test result? No. Can landlords ask about race, religion, national origin, or other protected class categories? No, they cannot. What if they don't act on that information? That's what people say, oh, we didn't act on it, we were just getting it. Well, why were you getting the information, right? And the housing provider will fail. In the one case, the Daytron case, housing price, well, he said, well, why did someone who had come in the unit would be compatible with the existing residents? The existing residents were primarily Filipino, and I guess a Black female tenant would not be compatible with other Filipino residents. That's illegal. It's unlawful. It's discriminatory. The court said it's facially discriminatory to even ask, even if without even proof that you acted on it. Of course, in this case, Daytron case, there was proof that the housing provider, the respondent, acted on it, wouldn't even let her in the front door to view the unit, turned her down right at the door, wouldn't even let her in once he saw that she was Black. So that is clearly discriminatory. Real quick, what resources are helpful in looking at these questions? What you can ask and not ask? Obviously, the first one is HUD regulation 24 CFR section 100.202. The House report, I've quoted and cited it quite a bit. And then HUD's implementation of the Fair Housing Act has a lot of information on it. So both the January 23rd, 1989 and November 7, 1988 statement. And then when it comes to reasonable accommodation and modification requests, I have the two regulations, one dealing with reasonable modifications, the second dealing with reasonable accommodations. And HUD has and DOJ have three joint statements. There's joint statements on reasonable accommodation and reasonable modification. There's also specific guidance when it comes to assistance animals. Those should be followed. And the National Fair Housing Alliance has guidance when it comes to COVID-19 and discrimination against persons with disabilities. So a lot of information, but I think we got some clear answers. I think there's some very clear answers when it comes to what someone can ask and not ask. So we serve, again, Wayne, Oakland, Macomb. If you notice here, we've added a county, Wayne County, and we also serve the city of Detroit. So we've added a county to our service area. We do work there, we do training there. So we're happy to serve, welcome service of St. Clair County. The board approved adding St. Clair County within our service area. We do housing complaint intake, investigation, testing, enforcement, and resolution of claims. We answer other housing related questions, training, education. When I say answer questions, we answer questions for everybody: municipalities, attorneys, owners, landlords, property management companies, anybody. We are funded, we're grant funded to serve our entire community. That includes everybody in it. We'll assist city council members and provide objective information. We are broad-based. Our board consists of people, for example, we have one board member started a 200-person property management company. We have a representative from a lending institution on our board. And then we have other groups as well, attorneys on our board and that. So we serve the entire community. Do not feel, oh, we're a housing provider and fair housing can't help us. You know what? If you have something that you're not sure about, ask us. It just shows you're committed to fair housing and you're trying to do the right thing. So please do not hesitate to contact us. 313-579-FAIR. Our website is fairhousingdetroit.org. We'll be happy to assist you. So thank you all for participating. I will stop the recording here, and provided I can stop recording, and then we'll go into our encore off the record Q&A discussion. Thank you so much for signing up. Please go to our website for additional webinars. There's quite a few of them, like I know maybe 10 more that are going to be offered. And again, this recording and PowerPoint will be put on our website. I'll put little links to various parts of it if you need to refer to a specific section. Thank you all for coming out. I really, really appreciate it. Thank you so much.